Mark, M-A-R-K, Brady, B-R-A-D-Y. I'm the chairperson, Narragansett Planning Board.
And just so we're clear, I will not limit you to this one time if you want to speak again.
Be short. I hope I'm not divulging anything. Excuse me.
Oh.
I do. Mark, M-A-R-K, Brady, B-R-A-D-Y. Thank you. I hope I'm not divulging anything that I shouldn't, but the chair and I had close to a 5-hour conversation on a Saturday. He put up with my coffee, and he's still standing, which says a lot about him.
Well, it woke me right up, so.
One of the things that we spoke about is communication. And I think a lot of the problem here is communication. I would like to set the record straight, and you can watch the video because there were a lot of time spent between the board, the planning board, and the two solicitors that this council hired as to what we could and couldn't do. We felt handcuffed. We were told by both councilors, separately and together, that we could not make recommendations and that we could not vote. It took us almost a half an hour to figure out how to send this back to you. So the detailed information that we normally would provide the council is absent because we were told explicitly throughout the process that we could not make a recommendation. We could give a thumbs up or a thumbs down. We couldn't even vote on it. And it took a half an hour to figure out how to even send this forward to you. So that didn't help the process. We ended up having 20 days to get this done when it was all said and done. And that's just the process. But, you know, going forward, if we can improve communications, maybe perceptions would get improved. I think a lot of this has been perception. And I have found in my experience, I'm exceedingly old and have a lot of mileage on me on top of that, is perception is a lot of times stronger than truth. So I would like you to know that what we normally would have sent back to you would have been far more detailed than what was sent back to you because we were told very explicitly, and we were reminded several times that we could not make a recommendation and we could not vote. So again, communication somewhere.
Thank you. And again, really appreciate the efforts, appreciate the open line of communication, and I do look forward to continue to build that rapport between the town council and the planning board. With that being said, if you wouldn't mind, Jill, if I start asking questions in regards to the recommendations, or at least the voting down from the planning board, starting with the concerns of the overlay districts. Councilor Collins, can I just see the law real quick? Right, no, right there. Thank you. So, at least with my reading of and understanding of the legislation, it reads, and this is as prepared by the state and written by the state, it reads, it makes clear that there can be no local regulation of coastal wetlands and freshwater wetlands beyond the requirements of the state agency requirements. So again, as it was recommended from our solicitor, literally just taking out the language, at least as it appears, to align to this state law as passed in June of last year. I'm just rather looking for an explanation or a better understanding as to where we're being misled, I guess.
Absolutely. So if you open up your book,
Yeah,
you'll see the same laws
of course.
under, which we provided to you under tab, it should be on tab 4.3, 4.4. So when you get there, it's General Law 452430.
Yep.
B, which says Upon the effective date of this section, a city or town shall no longer be authorized to adopt as a provision of its ordinance new requirements that specify buffers or setbacks in relation to freshwater wetlands. Our regulations are not new. They've been on the books since 1986. In the vicinity of the coastal wetland, or that specify setbacks and distances between on-site wastewater treatment systems. So I just want to point out, it says you can't create anything new. So the town of Narragansett didn't create anything new. We've had them on the books since 1986. Subsection C, just below that, says cities and towns shall be prohibited from applying the requirements of existing ordinances pertaining to both the buffers, wetland buffers, and on-site wastewater treatment system setbacks. So, and then it goes on. So I provided you at the top of that document the definition of buffer and setback, and both buffer and setback refer to freshwater wetlands. And those are the definitions right out of the Rhode Island General Law. Furthermore, with regard to our own overlays with freshwater wetlands, so we have 4.3, which is coastal and freshwater wetland overlays, which we did align with the state regulations in 2023. As soon as the law passed in, I think it was 2015, and then they had 18 months to promulgate the rules, and that didn't happen in 18 months. The state finally promulgated the rules in 2022, and then municipalities had a year. We immediately started working that in August of 22. We had a draft ready for the council in 23. It was vetted by all of our solicitors at the time. And what we did was we left the overlay section in the ordinance, but removed the requirement for a special use permit for freshwater wetlands. And we left it as a special review use. And the reason why we did that is because there are other sections in our ordinance which, number one, directly pertain to wetlands on site, so specifically minimum lot area, which is in other sections of our ordinance we could get into later. And also, it allowed us the ability to formalize the information that we were providing to our prospective builder or someone who is coming through. Hey, by the way, you've got a wetland on your lot. You're going to need to go to CRM, tell them their jurisdictional area, whether they're in CRMC's jurisdiction or DEM's jurisdiction. We'd let them know, or if they were within what we thought they might be within that area, that buffer area, we didn't control it, but we let them know that they might want to go to whatever body that was, CRMC or DEM, and get that either exemption or approval, because they need that in order to come to the town. Not to go too far into the weeds with DEM and CRMC, but DEM will issue a permit prior to 2022. DEM would issue a permit for construction in town without the town's approval. CRMC is a different animal. They take the last bite at the apple, and they will not issue an assent until the applicant has all of town approvals. So we try to inform and educate folks when they came through that, depending on what situation they're in. So we left that section in there as a special review use so we could continue to do that.
Thank you. Does anyone else have any questions or comments on the overlays while Jill and Mr. Brady are at the podium? All right.
Mr. Chair, if I could.
Yes.
Yeah, we provide information, as Jill said, but we also save time and money for developers, whether they're big or small, in coming in and not being surprised when they get to DEM or CRD. It's just an education. We're not in the enforcement side. We haven't done that in over a year. But we are in the information side, and we try to get them prepared. And it does save them time and money rather than having to go back and forth. So it is a service role. That's the way we look at it. That's the way we provide it. Thank you.
Thank you. So the other topic of conversation, again, I'm going to be asking I know that we have the information in front of us, but just for the general public, would you mind just clarifying the planning board's opinion on the special use permit?
For beer and wine?
Yes, thank you.
Was to not support the removal of the special use permit necessity.
Right. Yeah, and just elaborate on the reasoning.
Sure.
Oh, sorry, go ahead. Sorry.
It's in page 22 of your report.
Yep.
So I'm just going to
I
paraphrase from the
appreciate it.
report, but basically it says, the planning board found that special use permit for eliminating that special use permit need would reduce the public's opportunity to know about and comment on proposals of a new bar or restaurant in their neighborhood. The board raised concerns about a lack of clarity, and the board specifically, it does say right there in paragraph 1, 2, 3, 4, the board found no direct or indirect references to the sale of alcohol, but they did find that the that the proposed amendment is not consistent with comprehensive plan land use goal LU1, which is to make local land use decisions in an open and transparent environment based on sound planning principles and with the most accurate available data. The board found that it's not consistent because it's reduced transparency.
If I may, Mr. Chair?
Sure.
Just to relay the sentiments to the council. The council has the authority. You grant the license. As I've repeated over and over again to people to understand what the planning board does, we advise you, and we advise the zoning board. We're your staff. I've served on town councils. I know how much time it takes for you just to get through your agenda. So we don't subjugate your authority. What we do is walk through the technical sides, all the detailed sides. We put together recommendations to you and findings to you. It also gives the public a viewing, an opportunity to speak. It's an open hearing. It also gives the person making the proposal time to correct things or change things if they would like, and that has happened consistently. And then our recommendations go to you so you can make informed decisions. You have enough meat to go out and do your own research ahead of that, but not taking up and consuming time that you are required to do for other things. So we think in research we have found in other communities that this is a very proper and efficient way of doing things. The sentiment was that liquor licenses should be earned. We are in a country with an underage drinking epidemic. We are also in a community that we have a lively summer and a lively student body, and it gives us a vibrance in our character. But we also have problems with alcohol. We have deaths, we have car accidents, we have noise. And to take away another set of eyes, another process, another way of giving you detailed information, we just didn't think kept with the character and the mission of maintaining health, safety, and welfare of the community. We are also confused. Again, communication. Normally we would have had a workshop before this stuff went forward,
right,
and then we would have taken them. We didn't understand allowing liquor licenses by right in residential. We didn't think the town council would propose that unless you intend to do that. It didn't make sense to us. There are liquor licenses in residential areas, and they are by right, and they are held. Also, the special permit allows for review. So that didn't make sense. Also, again, lack of communication, but when we looked at it, the way it is worded, and not that it was the intent, but the perception was that, Dunkin' Donuts can come in and get a beer and wine license or alcohol. It reads that way. So these were the concerns. This is why, again, we were told explicitly we couldn't get into minutiae and stuff, but these were our concerns. This is why we came forward. I fully endorse trying to streamline things, but to expedite things in this manner, in this particular case, just didn't seem to be the healthy thing for the community. And that's why we recommend that the town council allow us to be your eyes and ears, allow us to be your staff, allow us to do the drudgery of getting you the detailed information you need to make an informed decision.
Thank you. Just along... Thank you. Mr. Callahan, can you just give a quick soundbite again in the spirit of streamlining processes. And again, I don't think anyone here doesn't appreciate an additional set of eyes. I do understand that there are a series of additional costs that are incurred to residents who may come before the planning board to seek special consideration, special use permits. But Mr. Callahan, would you mind just giving a soundbite, just for my understanding? Is this a general step in the process that is shared in other cities and towns in the state of Rhode Island?
Sure. I did a quick review of most of the state. I think there are about 12 towns and cities that do use special use permits for restaurants or with liquor. There are about 20 that do not. And there's 4 plus 1 that have a combination of that type of thing. In this situation, if you're applying for a liquor license, you apply through the planning division. You get a hearing before the planning board. They make a recommendation 1 month. Then the next month, if all goes well, you go to the zoning board for a special use permit where they review it, and then has to go to the town council for the actual issuance of the liquor license. So it's a multi-step process.
So with the proposed amendment, how many of those steps, just for the sake of clarity to the public and the councils, is with the proposed changes or amendments here, I should say, how many of those steps, how many, like, are we envisioning cost savings, time savings? What is the, and again, I appreciate you providing the service. You answered what the town council had asked, just providing a general context and the rationale behind the proposed amendment.
Right. The liquor board, the liquor control board in Narragansett is the town council. You have that authority by state law. Delegation of that authority to the zoning board or the planning board is somewhat questionable. It hasn't been challenged, but that's an argument. The reduction in time would be elimination of 2 steps in the process, the planning board and the zoning board, and the town council has all the authority within the state law to regulate any license it issues, time, service, area, all those things that you deal with on a daily, not a daily, but a monthly basis with new licenses and at the issuance of all the licenses on December 1st or approximately that date.
So again, since this seems like one that was not intended to align with any state law, but this was answering the second half to better streamline processes for residents and the cost savings, it sounds like. Are we able to put a number on like an approximate amount of time at least saved? Like, what is the general amount of time if I were to come forward and ask for a special use permit? How long would that take?
I would think it would save 2 or 3 months at minimum.
Okay. And then one other point that was brought up was the concern about issuing special use liquor licenses in residential neighborhoods.
Right.
That myself, I was confused when I heard that as a concern, because from my understanding when I read this, and this is all in the spirit of communicating, that is not what I interpreted. So if this is true, can you just please confirm that?
Right. I think the concern would probably be the expansion of a legally non-conforming full-service restaurant to allow a sale of beer and wine. I mean, that probably, I can't think of many places that would be applicable to, but I'm sure there are places in town where they could apply for a liquor license under this situation, where it's currently a special use permit. It'd be a license you would have to issue just straight from you. So I think, like I said, this whole situation, there are going to be amendments. And this is one that I think Jill and Mark definitely can weigh in on and give the council guidance on, because, I mean, I suppose if a Dunkin' Donuts shuts down, they could call themselves a restaurant and call themselves again later on, ask for a liquor license. That could happen. But I'm not sure if that's the worst thing or the best thing. Who knows? But that makes sense.
Thank you.
Mr. Chair?
Yes.
If I could, just
Yep.
one last. I mean, what you're looking to do is exchange expediency and sacrificing transparency. And we're asking you to consider that. Again, we work on your behalf. We're your staff. Let us do that. I mean, even as thorough as we do, you at the end, it's on you. You make the decision, but you make an informed decision. You make a formed decision that's technical, that has been researched in all areas. We have the expertise. We do this. This is what we do. Take advantage of us. And keep the transparency. That's the one thing that this council has preached. This is the reason why I voted for you, is transparency. Now, if you go straight to the council, and I've seen it, it's not this council, it's never this council, but somewhere along the line it becomes a political thing. Some friend of a friend. Yep, no problem. And it happens, and it will happen. I'm asking you to look at your legacy and see what you're going to leave behind. Thank you.
Thank you. Does anyone on the council have any other questions or comments for Jill or Mr. Brady?
I would just ask of Jill and Mark the same question that was asked to Solicitor Callahan. What is the length of time between receiving a special use permit, going before the planning board, zoning boards, and that all being turned around?
Sure. So when you get scheduled for the planning board, it is a 1-month turnaround. It depends on when your application is submitted. It could take a month to get onto the planning board. If you submitted the Friday after a planning board, you're not going to get on for another 3.5 weeks. And then it does, because there is a public hearing notification requirement for the zoning board, that we can't, well, we might be able to actually streamline them and do them back to back, but typically it's a public hearing notification. So once the planning board makes its recommendation to the zoning board, once they vote, they find completeness and conformance with the comprehensive plan, and then they vote to make a recommendation to the council, to the zoning board, then we have to notify. We have to put it in the paper. The butters get notified. And that takes time. That takes about 20 days because we have to put it in the paper, and the paper wants it 14 days in advance, but the paper wants it 20 days in advance. It's a little bit time consuming.
Counselor, I will tell you, as a practice, we expedite anything to do with the business in this town.
Oh, we do. That's
expedite it on fire. It always goes before. Do we cut corners with it? No. We do our due diligence, but it is always a priority. Things are moved off of our agendas to make room for business, any business. Business is a priority of ours. We work with them to try to move things along as efficiently and as quickly as we can, not just because it costs them money and time, but it benefits the town to have new business. We thrive on that. Outside of tourism, commercial is our bread and butter. So we expedite things. And we do coordinate with the zoning board, and we do try to do back-to-backs. If we can facilitate that, we will make it happen.
Thank you.
Thank you.
With regards, and thank you, Jill, for mentioning that, just streamlining the process and the back-to-backs. If we were to streamline things, what would be that window of time where we could have a zoning review, a planning review, and then a zoning review? Is this 5 days, a week, 2 weeks, a month?
Well, so without changing any meeting dates, right? What it would be is it would be the public notification prior to the planning board having met. So some towns actually do that. There's a couple of towns, they do planning 1 week and then zoning the next, but they've already pre-advertised for the zoning. It's good and bad, right? Because it's good because it streamlines, it moves things along, and you could be done within 2 days. And oftentimes we will do that for business. We will put them on, we will schedule them for the public hearing portion of it, doing all the notification, and then do planning and zoning in the same week. It sometimes can get tricky, especially with residential, because there's a lot more moving parts. Things tend to change a little bit more. The site plans change. Certainly with restaurants, it's basic site plan with the parking, and it's the interior floor plan. Things don't generally change. Your kitchen is where your kitchen is. You're not moving it. So the short answer, Mr. Torialde, is it could be streamlined for businesses to move that to that Tuesday, Thursday meeting. It would just require the pre-notification. And if something got held up, then the public hearing in 2 days could get held up.
Okay. Understood there.
I would like to relay a smackdown I got from a judge in my younger days. I once made the statement to him, because I knew better, you know, my client has the right to do what he wants with his land. And the judge immediately looked at me and said, your client has the responsibility to make sure that the people around him have the right to enjoy their property also. That's part of this process. It's a big part.
Can I just ask a question?
As long as
Oh, I'm
Councilor
sorry.
Torialde is.
Go ahead, I apologize.
Just go through his questions first.
Just, I missed it. We're going, if we were to streamline things, we would go from roughly a 50 to 60 day turnaround period down to, because of public notification, I
Sure.
understand that.
So the application has to be submitted. It has to be reviewed. We have to write a report. There's still things that happen behind the scenes before meetings are scheduled. So you're still looking at between 30 and 45 days, depending upon when the application is submitted. Sometimes it's a lot less, depending on what our workload is. If you, like I said, if you submit the day after the planning board meeting, it could be 30 days before the next planning board meeting.
Okay.
And one of the things we have to do is, as board members, we go on site. We go, any proposal before us, we go to the property and we walk. We can't go on private property, but we'll walk the neighborhoods. That's part of our research. So it takes us, we need some time to get out there. But again, we flag these. We try to get these through as quickly as we can.
Okay. Thank you.
Thank you.
Councilor Vignali?
So one of the concerns that came to me when I have been doing my research, someone actually, some of the people who I spoke to were talking about Monahans and how long it took them to get their wine and beer license. I was wondering, how long of a process was that?
Monahans applied twice.
I'm sorry.
They applied twice. The first time they were denied. I could go back and look at the reasons, but the zoning board denied the special use permit.
Okay, and then they.
And then the
applied-
second time they came back, I believe it had to do with alcohol security.
Okay,
But
I'm just
I
curious.
don't want to
'cause-
get into the particulars of a particular
No,
project.
no, that's
I'm
fine.
happy to talk to you offline about that.
No, that's fine. Just someone had brought that to my attention, and I just wanted to inquire.
It's been brought
Thank
up to
you.
me too. So
So I guess the last comment I would make is, again, I appreciate the planning board, the zoning board, all of the efforts that you guys, and all the projects that are undertaken, but I also see and hear from you guys and from a lot of other members within the public that it is an extensive amount of work that you guys do. So again, in the spirit of trying to streamline processes, I would ask that while there's a consideration of continuing this public hearing, if it's the consensus of this council, if there are ways in which you can think of ways in which we can streamline these processes to help you out, where I'm all ears, because again, in the spirit of streamlining processes, not only are we trying to appeal to the residents to try to help out the residents, but we're also trying to take some of the workload off of your plates. So,
I think that is something that we need to work on outside of this. I don't think that's a stand up here and start throwing stuff up against the wall. I think we really need to go through, and we have the people on the board to do it. Our board has a billion years worth of experience in this, in many different settings, at many different levels. And I feel very confident that we can look at systems, and we try to. Right now, frankly, we've been trying to deal with a fire hose of the state, making changes every other day. And I'm not throwing stones. This froze everything for us. We're about 6 months behind right now, trying to deal with this. So on a day-to-day basis, we're not drowning, but I think you're right. I think it always helps to look at how to make things more efficient. Not streamlining for streamlining's sake, but how to make things more efficient, less costly, et cetera, so forth and so on. And I think there's always room, even if it's small. And we would commit to doing that. But I don't think that's something we can be throwing out here ad hoc. It would be irresponsible.
Appreciate it. And Mr. Brady, since you are up here and I don't have any additional questions or comments to say, and since you've been sworn in, and to allow other members of the public to speak as well, is there any additional final thoughts or comments on either of these two?
No, I think we've tried to give you here what we couldn't give you before, but again, it's still not detailed because we weren't given the leeway to vet it completely as a board. I don't feel, none of us felt good about what we sent to you in the quality and the level of work that we are normally known for doing. But we worked within the confines of what we did. My recommendation would be, and I'm just throwing this out, guys, don't everybody get upset and don't you guys get all excited. My recommendation is vote the whole thing down and then send it back to us. Let's have a workshop. Let's go through, take the low line, please stop. I'm sorry. Let's pick the low-lying fruit, have a workshop, get back and forth. You guys can do a formal proposal, because what was sent to us wasn't even what we're used to as a legal ordinance. Send it back to us. We can have hearings. We can vet them. We can get back to you, and we can work together as a group. That would be my recommendation. Short of that, we will try to provide you each night with what we can, but again, we were limited in what we could do.
Yep,
So
understand that.
thank you for your patience. I
Thank
appreciate
you.
it.
And just so that I'm clear again, I understand, and it's been shared this evening, could the process have been improved from the start? Yes. This public hearing was advertised. There's a substantial cost due to the length of how it had to be advertised. I did come into this with the same desire to kind of share my opinion about how everything should be considered individually. But while we are faced with a public hearing that we've opened, and we have the opportunity to at least review and discuss and use the public hearing as a workshop, and there is no hard deadline for when the public hearing can close, and to my discussions with the solicitor, we can workshop this while the public hearing is open. You know, I think, again, as long as everyone is willing to come to the table, I'm certainly willing to encourage workshopping through the public hearings and then maybe separately as a result. But again, I'm also mindful of your time as well, and I understand that this has put you guys back a little bit as well.
It's fine.
Okay.
You know, we all are trying to do it right, and as we committed to each other,
Yep.
you know, we'll do whatever we need to do, whatever you need us to do, and we'll do the best we can through this process. You might get frustrated in the fact that we're going to have limited information because that's what we were given as direction. And I'm just clarifying that. I'm not throwing stones. I'm
Nope.
not blaming anybody or anything. I don't
Understood.
want any of that crap. It's not constructive. I'm just telling you, we will do the best we can on your behalf throughout this process.
Excellent. Appreciate that. Thank you so much. And with that being said,